questions. Are there any questions?
Mr. President.
The Leader of the Opposition.
Mr. President, my question without notice is to the Minister for Primary Industries and the Minister for Lands and Water. Minister, what is your response to community concerns about uncertainty in your department's advice to more than 500 Crown land tenure holders who were told that despite their tenures being extinguished as a result of native title determinations, they can continue to use the land?
Good question. Again.
Is there any independent appraisals of that question?
Mr. President, I thank the member for his question, and it is a good question, and it's actually a question that I myself asked at the original stage of this issue of the department, and it's something that the department has come back to me and advised me of. I'm advised that around 520 Crown land licences and permits in the north and west of the state have been automatically terminated following the Bungajang, Yagal and Barkadji determinations due to a clause contained in those agreements. In any cases where the recognition of native title has had an impact on Crown land tenures, the government is committed to working with all parties to address the issues. Preliminary discussions have been held with native title groups. I reiterate these discussions are preliminary and will no doubt be ongoing as the department works through what is no doubt a complex and sensitive issue. At the start of September, the Department of Industry Lands wrote to those 520 licence and permit holders directly, notifying them that the department is reviewing all affected licences. A second letter was sent to all affected licence holders at the end of September, providing further information on the process for this review and likely timeframes. The department will be holding community information sessions in the Far West and North Coast of the week, which commenced earlier at the start of this week, 10 October, to address any concerns and provide these communities with information on the process moving forward and an opportunity for the community to raise any concerns. The department will work to ensure that tenure holders and native title holders are engaged in the process of recognising the coexistence of each other's rights, which is fundamental to the native title system. The Native Title Act 1993 Commonwealth provides for Indigenous Land Use Agreements as a possible mechanism for the agreement making between native title holders, government and other land users. The government encourages their use. The department is reviewing each individual affected licence. Where a licence is consistent with the future Act provisions under the Native Title Act and the land is being used consistent with the Crown Lands Act, the licence will be reissued as quickly as possible. Where the licence is unable to be issued under the future Act provisions of the Native Title Act, the licence may be potentially granted under an ILUA. Some licences that are not consistent with the Crown Lands Act will not be reissued. This does not affect holders of other Crown land tenures such as leases. So, Mr. President, this is an important issue. It's a complex issue. The correspondence that was sent to those licence holders was sent after careful due diligence and advice that had been sought on the status of those title holders. So it is my understanding that any advice that has been given on this issue is the latest advice. It has been checked, and those people that are affected should have confidence in that advice. However, as I've said in my answer, workshops are being held. If there are issues that people want to raise, they also have been contacted directly by the department and can continue to engage.